Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Good morning, everybody. Happy Friday. My name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. Welcome to our firm's February live virtual First Friday event. I've worked with and represented HOAs and condominiums in the state of Arizona for over 28 years. Wow, it goes by very fast. Seems like just yesterday, I was starting my firm at the young age of 26. My firm currently represents over 1,000 planned communities and condominiums throughout the state of Arizona. And I also currently serve on my Master Association Board and Sub-Association Board where I live. Here's how First Fridays is going to work today. If you haven't already, please submit your First Friday questions in the Q&A box on Zoom or in the comments section on Facebook Live as soon as possible. And then I will be answering all questions between now and about 10 or 10:30 this morning. We already have over 50 questions this morning as of 9 a.m., which is amazing. Just a quick friendly reminder, due to the large volume of questions that we receive, this free opportunity is limited to one question per association. So if you plan on submitting a question live during this session, please be sure to include the name of your HOA or condo and your current role when you submit your question. Thank you for understanding. Okay, a couple housekeeping matters before we dig into the questions this morning. First, I want to give you a quick little Corporate Transparency Act update. Basically, there's really been no change from when I last talked with you in January for our Neighborhood Services Virtual HOA Academy, the third Tuesday of January. Basically, the government is appealing again the decisions in a separate court in the state of Texas. And so really the status quo right now is that associations do not have to file the Corporate Transparency Act BOI form, but that could change. So stay tuned. There is a stay still pending in a second case out of Texas, and there's all kinds of appeals that are being filed in the United States Supreme Court and other appellate courts on this issue. Just one kind of thing that we've been thinking about a lot about the Corporate Transparency Act. A lot of associations decided just to file it anyways because they don't want to deal with the hassle of the whiplash from, that it's on, it's off, it's on, it's off, which we have been engaging in here with the court system and the government since, December. So if your association is interested and you want to just comply with it because you don't want to get stuck with very short notice to file it, please reach out to our firm. We can help you with that. We have a set price to do that. And we do the free updates throughout 2000 if any board members change or whatever throughout the year as part of that package price. So keep that in mind if your association, if you haven't done it yet, it's something that either you need to be ready to file it, so have all the paperwork done and then just file it once the government gives the green light that you have to file it, or just do it now and comply with it, which is what basically 99% of our clients did, just because they don't want the hassle of having to keep watching these cases. And I truly can't tell you, I don't know what the government's going to do on this. There's some bills pending in the United States Congress to eliminate it for HOAs and condominiums and other organizations. And there's many lawsuits pending. And I don't know what's going to happen on this. So I have inclination, but I think probably it's best just to file it would be my inclination. Okay, let's talk a little bit about the Arizona legislature. Wow, the legislature in Arizona has been in session now for just under a month, and it has been very busy with regard to laws pertaining to HOAs and condominiums. A couple of thoughts on this. This is going to be a big legislative year. I know we say that from time to time. Kind of the last slow legislative year we saw was in 2020 regarding HOAs and condominiums. I spent probably 2 or 3 hours last night preparing a summary along with Emily from my law firm, who is doing an amazing job helping me monitor it as well. And so what we did is we put together just a quick summary of the 20 bills And we're going to be sharing those with you shortly on Facebook Live and Zoom. Remember, these bills are pending in the legislature. They are not the law yet, and we will continue to monitor these bills. I guess the overriding thought on the bills for this year, 2025 legislature, is just more regulation of HOAs and condominiums, which is really kind of stinky, frankly. I was going through the bills last night, and associations, it's a private contract between associations and the owners. And I think the amount of government regulation on associations is getting to the point where it's making it almost impossible for us to have our clients stay on top of the new laws, and just all the regulation of them is really, in my opinion, unnecessary. Yes, there are a couple associations that aren't following the law or maybe are outliers and are on the news or something. But like 99% of the associations in Arizona are following the law and doing what's best for the association. So it's really disheartening to me as somebody who's practiced in this area for 28 years to see all of this constant regulation that's being proposed of associations. That's unnecessary and just makes it more expensive for all the homeowners in your association. So that's my 2 cents. The 20 bills are in the summary. We will be updating the legislative summary typically right about before we teach each class each month, so about twice a month. So we'll update it with the first Fridays every month, and then again the third Tuesday of the month when we teach our virtual neighborhood services HOA Academy. So stay tuned. If anything big happens on the state legislature, I promise we'll be talking about it on our social media, in these classes, or on our Mulcahy memo. If you're not getting our Mulcahy memo, which is just an email that we send out once or twice a week on any updates that would be helpful for you or any information that will help your associations effectively run better, be sure to reach out to me at info@mulcahylawfirm.com, and we'll be sure to add you to that list. Okay, let's get into the questions. I'm just going to do a quick check how many questions we have. We're up to 51 questions right now, which is amazing. So let's dig right in. The first question is from a board member. Can a board hire a management company without an approval vote of the membership? So I'd have to see your documents to answer this question, in particular. Obviously, I'm not your attorney, and I haven't reviewed your documents. And it's important that I say that on these calls, the free call-in. So I'm just answering based upon my expertise, 28 years of representing associations. Okay, so based on my experience, most boards do not have a requirement in their documents to have the ownership or the membership approve a management company or approve to go with a management company if they've been self-managed. But occasionally the documents may say something like that. So I don't know what your documents state, but probably 10 out of 10 times, almost a very high percentage allows boards to hire vendors, and a management company would be the typical vendor that could be hired or fired by a board. Now, if you're a very small self-managed association, it's possible that your documents may say something like you need membership approval. Check your documents to be sure. Okay, second question is from a board member. Our 12-unit HOA faced a major setback when one unit owned by a severe hoarder caught fire on January 20th, 2025. I'm really very sorry to hear that. Our insurer, State Farm, is handling the claim, but requires asbestos removal before assessing the full damage. Wow, the facts on this are sounding just like a facts that I've seen on another matter in 2024, which was not a fun matter. So I feel for your association here. It's still pending and has a lot of issues. So the problem here is that our insurer, State Farm, is handling the claim, but requires asbestos removal. I already said that. Okay, they indicated it's a significant loss and will provide me, the HOA president, with a check once everything is settled. The unit owner has cognitive challenges and is a squatter who may have caused the fire and was living there, although arson has been ruled out. My main concerns are determining responsibilities for rebuilding, protecting the vulnerable owner from potential scams, and ensuring proper management of the insurance funds. Can a guardian or some legally responsible person be appointed for the owner to ensure that the unit gets rebuilt appropriately? I'm deeply concerned the owner is a vulnerable target waiting to happen for any construction or other scam post-fire. And I think you should be concerned about that because I have seen a number of cases over the past decade with fires that have frankly just not been handled well. I really, truly encourage you to reach out to our firm to help you with this process. Just a quick answer on this would be your insurance company has hired like an adjuster to come out and determine how much it's going to cost to rebuild everything. And when there's asbestos removal and there's total destruction of the property, there's usually are major code upgrades that are needed that may not be covered by the policy. And the asbestos removal may or may not be covered by the policy. So you really need somebody who's been through this process before to be helping your association. Also, you've got the added factor that this person that the fire was in his or her unit has some cognitive difficulties. The good thing on this is that hopefully the insurance company is putting that person up in separate housing. And if they have any family members, we may need to strategize about some discussions, important discussions that we may need to have with them regarding the future of this unit or lot so that this doesn't happen again. I guess the biggest thing that I would be concerned about is you're going to be getting a bid from your insurance company in terms of how much they think it's going to cost to rebuild. You also should be making a claim, or the owner should be making a claim on his or her policy. If any other units have been damaged, those owners need to be making a claim on their policy. The money typically from our insurance company will go to the association's board, and then we'll be paying the vendor as they do the work. But this is a very complicated process, and I genuinely hope that you will reach out to me and have our firm assist you with this problem because this is a challenge for sure. Okay, question 3. If this is from an HOA, if not prohibited by the CC&Rs, is there any Arizona law that prohibits the HOA from amending its bylaws to require HOA members to maintain an all risks homeowner policy, so an HO3 policy, for the entire structure and limit the HOA's insurance to just liability and D&O coverage? You're indicating that you're an HOA. I don't think you're a condo based upon what you're telling me. So I think that I'm not aware of any law in the Planned Communities Act that might address this. If you're like a townhome and technically classified as a condominium, there may be an issue here. So what I would recommend is reach out to our firm. Let me look at your documents quickly, and we can help you determine whether or not you can push all that insurance to the association's membership. Question 4 is from an association. We just had elections in our community, and there was an issue with some of the ballots not being counted. So now we are having an issue as to who was actually elected. My question is, shouldn't we do a revote of everyone? Really, it's not necessary to do that, and you honestly could be challenged by the existing candidates if you don't properly count the votes from the first time. So what I really recommend is you should have your attorney or our law firm help you count the ballots again to determine who's been elected and what the proper terms are. Question number 5 from a board member. How does an association go about reducing the number of board seats? Is it possible? So technically, the number of board members is listed in the bylaws, maybe the articles or the CC&Rs. So you just have to amend the section in the CC&Rs that talks about how many board members there should be. Sometimes in the documents, it says that the number of directors is fluid, meaning it can be not less than 3, but not more than 7. If that's the case, typically your board can change the number of board members without a vote of membership, and they just do that at an appropriate time, like maybe right before the annual meeting. Or, maybe if you're appointing more directors, you might be able to do that in between annual meetings. And that typically can be done in an open board meeting where a quorum of the board is present. Okay, next question from a board member. This board was provided information on our firm's, let's see here. So this board meets for board training that is required. You know what? I'm a little confused on this one. Maybe let's move this to the end because I think I may have messed this one up. So sorry. Let's move that one to the end. Okay. Next question is from a board member. Are published meeting agendas required to have any legal verbiage included? So the legislature didn't really give us any direction on the open board meetings. So what I would, and just as a backup, under Arizona law, just so you know, the legislature changed the law last year, and all associations must give a meeting agenda 48 hours in advance of the meeting. And so I think this question kind of flows with that, in that how much detail do we have to provide on the agenda? And so really the answer would be, if it's a executive session agenda and you would be required to give 48 hours notice of an executive session and 48 hours notice of an executive session agenda, you're going to have to indicate on that agenda what specifically under the law, which section under the executive session law you are going into executive session to discuss. That's going to be very important to have on the agenda. And you may have things like approve last month's meeting minutes and new business and maybe pending legal matters or whatever, but you have to cite specifically what section in the statute for executive sessions that must be on the agenda. For regular board meetings, it's a little more loosey-goosey. I mean, what I would say is have as much detail as possible on it. If you're looking for a good sample of the type of things that would be on an agenda, you could go to our cheat sheet called Board Meetings, and it says how to take perfectly proper meeting minutes. And I give kind of a sample meeting minutes that would be kind of a good backbone for an agenda. But it's going to basically be the same stuff every month. Review, last month's meeting minutes and vote on them. Treasurer's report, president's report, manager's report, new business, old business, and then adjourn. A question I get a lot is, well, what if something comes up a day before the meeting and we want to add it to the agenda? I'm okay with you doing that, as long as just send out a revised agenda to everybody, just saying, hey, this has been added. Or if it's 5 minutes or an hour before the meeting, just throw it in under new business or old business, depending on if it fits. But what I don't want to see happening is boards strategically withholding putting things on the agenda on purpose. That's not a good idea, and that's going to result in challenges to your association under the law. Okay, next question is number 7. We have moved away from the HOA group insurance to individual homeowners being responsible for their own overall, so outside and inside of their home insurance, and we're a condo. We've asked that they put additional insured on their policy as opposed to additional interest, to ensure that the association is always informed that homeowners are insured. If they cancel their insurance, we're notified, or if they fail to renew their insurance, we're notified as the additional insured. Which is the better way for the HOA to ensure that the homeowners have obtained insurance, as an additional insured or as an additional interest? And which one gives better protection to the HOA? This is a great question for your insurance agent. I would reach out to them and ask that question. My experience is being an additional insured is something that is regularly done, but maybe they're adding this thing. I've never even heard of additional interest, so I'd be curious to find out. Maybe that some insurance companies have added this as a way to help HOAs better manage this process. So check with your insurance company to see what they feel is best. My experience has been adding as an additional insured meets all the things that you're needing as per your question. Question number 9. This is from a manager. So great to see manager here today. Thank you for being here. The townhome community I live in is responsible for the exterior paint. The paint is flaking off the exterior in dinner plate sized pieces, and has been like this for over 2 years. I have been unsuccessfully trying to sell my unit in the complex because the board and community manager are not fixing this issue. No one wants to buy into the community. Would a complaint to the Arizona Department of Real Estate get the association's attention, or can you suggest something else? So I definitely think going to the Arizona Department of Real Estate, when you'll have to file a claim there or a complaint there, and you'll have to pay the $500 filing fee, that will get their attention for sure, because they'll have to respond to that once they receive it from the Department of Real Estate. And you can find the forms to do that by just Googling HOA and the Arizona Department of Real Estate, and the forms will come right up for you to do that. You can do it online. Another thing that you might want to do is go to a board meeting, talk about it with them, run for the board yourself so you can make positive change and get this done. Let's see. You could hire an attorney to write them the board a letter demanding that they take these changes. You could get a petition going to remove the board. There's lots of different options for you here. I'm sorry this is happening. Hopefully your board will wake up and start moving on this. Okay, question number 10 from a board member. We recently raised our master insurance deductible. One thing I'm going to make a comment on here today, we're getting a lot of questions on insurance. So we're starting to plan our classes for the second half of 2025. And I think we definitely want to be talking about insurance based upon all the different insurance questions we're getting here today. Okay, back to question number 10 from a board. We recently raised our master insurance deductible for our insurance policy and advised our members to ensure their homeowner's policy had sufficient coverage to pay the master policy deductible in the event of a loss. However, we are aware that many of our members own their property free and clear and may not have their own insurance, which would make them potentially responsible for the deductible. Can we require them to carry homeowner's insurance and provide proof even if they don't have a mortgage, which would require it? So great question. I mean, really the best way to do that would be to have a section in your CC&Rs that says that the homeowners have to carry a certain type of insurance, and then also that the homeowners have to make the association an additional insured on the policy so that we're notified in the event the owner makes any changes to the policy, doesn't pay the premium, or doesn't renew it. So the best way to accomplish making sure that the owner in your condominium has insurance is to do an amendment to the CC&Rs. Now, I don't know, I'd have to look at your CC&Rs. If you reach out to our firm and hire us to look at your CC&Rs, I can let you know whether or not maybe your CC&Rs already have that requirement in there. But I'm guessing it doesn't have the requirement to have the association listed as an additional insured, because we just don't see that very often unless we add that. Okay, next question, number 11 from a board. Can an HOA conduct business such as an appeal vote over the internet and by texting without calling a meeting? And does the open meeting law apply to such correspondence and communication? So we have a great cheat sheet on the open meeting law on our website at mulcahylawfirm.com that I would really encourage you to take a look at. So, I mean, really the bottom line is you shouldn't be doing any voting on email or over the internet as a board. Really, anytime a quorum of the board is meeting to discuss association business, it needs to be an open board meeting where owners are allowed to attend and participate if they so choose. The only exception to this would be where I would allow a internet vote or email vote or text vote is if there was an emergency and we couldn't wait 48 hours to notice the meeting. But other than that, I'd be really careful about making decisions as a board outside of an open board meeting that's been properly noticed. Now, if your board is doing this, you shouldn't be. You really should be at the next board meeting reaffirming the decision. The decision that was made outside the meeting. So there's a paper trail in the minutes, because really if a court looks at this matter, if it didn't happen in the minutes, the court may say this didn't happen, the board didn't approve something. So really important that the minutes reflect what was decided. And same thing for emergencies. If you have an email vote or text vote by emergency, state law requires that decision needs to be read into the record and minutes need to be taken for that emergency meeting and read into the record at the next regularly scheduled board meeting so that there's a paper trail as to the emergency and why it occurred, what happened, and how it was handled. Okay, next question, number 12 from an owner. Great to have you here today. In August, my condominium board voted to pay for the association's lawyer to create an insurance matrix that details who is responsible for what. Meaning the owner's responsible for this, the association's responsible for this, what's a common element, what's a limited common element. It was sent to owners in October, but it was not approved at a meeting, even though it says it was approved in September. So I'm not sure what the question is, but I do like the fact that your association's doing the maintenance matrix so that people know what they're responsible for and what they're not responsible for. I think maybe you're getting to the question is it was sent to the owners in October. There's no minutes to support that. Kind of goes with the prior question. Boards need to be really careful that maybe this was something that was done in executive session because the lawyer was involved. I don't know. And maybe that's why you don't know about it. But just a good friendly reminder that anytime a board is making a decision on something, it really should be in the open meeting. Now, in this case, because they were consulting with their attorney, maybe it was proper that it was discussed during the executive session and you wouldn't have access to the minutes to that to know that it was discussed. Okay, question number 13 from a board member. We have a renter who is disabled and uses a wheelchair to get around in the neighborhood with his dog. His dog is very large, like a Saint Bernard, and is never on a leash. The dog is not assisting him in pulling the wheelchair. Oftentimes, the dog is far ahead of him. His dog has been known to jump on other neighbors and to be aggressive with other dogs in the neighborhood. He claims the dog is a service dog, but he has no control over the dog. We would like him to keep the dog on a leash. What questions may we ask him regarding the service dog, and can we ask him to keep the dog leashed? We have brought this up with the homeowner, but she claims that since the dog is a service dog, we cannot ask her renter to leash the dog. Okay, lots of issues here, kind of like a bar exam question. First things first, if you go to our cheat sheet on federal laws, which you can find on our website at mulcahy.com, there is some great information on assistance animals, service animals that I think would be helpful, just like a general baseline knowledge. So here is what I recommend that you do on this particular dog. I mean, it's obvious that this renter is disabled because they're in a wheelchair. Whether or not this is a service dog or an emotional support dog, we don't know. And so you need to kind of tread lightly here. But what I would recommend is maybe have our firm send the owner a letter, landlord a letter regarding the tenant, and ask for more information regarding the service animal and find out, is this a service dog or is this an emotional support pet? And ask for, a doctor's note regarding the service animal. We may want to remind that all dogs need to be on a leash. And obviously, once we receive the information regarding the service animal, we can evaluate whether or not this animal needs to be on a leash at all times. It's going to be kind of a carefully worded letter, so you may want to reach out to our firm to help you write it. And then once they provide the information, if I had to guess, I've really never seen a St. Bernard be a service animal. I have seen maybe a St. Bernard be an emotional support animal. The emotional support animal would have to have the leash. So it'll be important that we get that information from the owner directly. We don't have a contract with the with the tenant. So we'll want to be talking with the owner about this tenant's service pet. Okay, next question is from a board member. What do we do when a board member regularly violates the executive session criteria? Okay, well, we have a great cheat sheet and many blogs on, executive sessions that I would encourage you to take a look at. We're sharing it with you right now on Facebook Live and on Zoom, so you'll have it at your fingertips. You can also find it on our website at mulcahylawfirm.com. Okay, so what I would recommend is take the cheat sheet and show it to your board and be like, hey, we have to be very careful. We're talking about an executive session topic or a non-executive session topic. I don't know what the violation is. So you didn't tell me, you said they're violating the criteria. So maybe what I'm guessing is happening here is they're talking about non-executive session topics during the executive session. So give the board the refresher regarding open meeting laws and executive sessions via our cheat sheet or via anything that we have on our website that talks about it. Encourage your board to watch any videos that we have on our website. We have a lot of videos on how to run a board meeting and ins and outs of executive sessions, etc. Maybe this board member just doesn't care about following the law. If that's the case and they're not receptive to getting education, what I would recommend is that you document your concerns in writing at a board meeting. And you could do that by making a statement and asking them to have it in the minutes, which I'm pretty sure will not go over well with everybody, but it's kind of draws a line in the sand and says, hey, I'm serious about this. We need to follow the law and I don't want to get sued. You could hire an attorney to write a letter to the board. These are all different things that you can do. Okay, next question is from a board member. What can be done to prevent large institutional real estate firms from buying multiple units, taking over leadership of the board, and forcing condo owners out with the conversion to apartment complexes? So I saw this email came in yesterday, actually, or maybe the day before, from this particular board. And they gave me like a whole list of things that there were some strategies that, to go into a board. Like an investor would be buying one unit in the association and then they want to take over the board. So it was kind of a scary article. And I think it was just kind of something that was on the internet. But when I read the article that this board gave me, I was like, yeah, that's pretty much how somebody can take over a board. It's scary that they might be able to do that. So I think this is kind of a hypothetical question for this association. So what can the board do or what can owners do if we've got investors coming in and buying a lot of units and they're trying to take over our association? I think associations can't prohibit buyers from buying units or lots in an association. So I know a couple of associations have come to me recently and have said, we would like you to help us with an amendment that says that investors can't own a unit or a lot in our association, or investors can't own more than one unit or lot in our association. I don't know if that would be enforceable in a court of law, so I'm kind of wary on that. I think what you want to do is talk about this issue as a community. Have a meeting or a town hall, and if this is a serious issue that could happen, bring in an attorney our firm would be happy to help you to kind of go over, hey, what does this mean for our association if this turns into an investor property where we have a lot of rentals, or that they try to take over the association and force us all to sell at a lower than market rate. And then talk about what some strategies are that we can do to prevent this. And, some of the best strategies I can think of are communication. Have a town hall meeting and talk about the issue with your homeowners so that they are mindful of this potential issue. And what you could do is maybe put in like a right of first refusal in the CCNRs. I mean, there's lots of different things that you can do. But the first thing I would say would be to open lines of communication and talk with your owners about this issue. Maybe when people are selling their property, maybe they voluntarily offer it to other owners in the community first before they would put it on MLS. I mean, there's lots of different things that we can think about, but communication is the key to start talking about that. Okay, question number 16 from a board. When an association is out of operating funds due to poor budgeting, can it borrow from the reserves? If so, what terms and conditions apply? So we see this question frequently for associations that maybe are low on funds and it's a problem. They don't have enough funds to run the affairs of the association. So they have to dig in and take money from the reserves to meet their financial obligations. It's not a good situation to be in. Check with your CPA first and see if they have any special requirements. My experience has been if you do borrow from the reserve account, you should try to pay it back within the same year. And this should all be documented in writing in meeting minutes. It's really something that you don't want to do. So if you're in this situation, you need to be looking at your budget. Do we need to increase the assessments so that we can meet our financial obligations? Do we need to have a special assessment? Can we have a special assessment? All of those things are important things that you may want to consider doing. In an emergency, can it be done? I have seen it done. You just want to make sure that you do it right. And then try not to do it going forward. Maybe you get in a pinch once and then pay it back and then definitely try not to do it forward with good budgeting. Okay, next question, number 17. Does the ballot for an annual meeting require a write-in line for a board candidate? If yes, would it negate the election process and require a new ballot and meeting date? So great question. No, the ballot does not typically require a write-in candidate line unless your documents require it. So most associations don't put that on their ballot because they have candidates that they have solicited who have volunteered and have given us their bios to run for the board. So they don't want just like some random person getting written in and potentially, gaining enough votes to win the election. Although honestly, write-in candidates, it's very difficult to win as a write-in candidate because most of our elections now are done by mail-in ballot, and there would have to be a really strong grassroots effort to have a write-in candidate get elected. But so bottom line is, does a ballot require a write-in line? No, not unless it's in your CCNRs that's a requirement or in your bylaws. Okay, question 18 from a board member. We had to condense this question because it was a little bit long when you submitted it, and just kind of a pointer here for First Fridays, please do your best to try to condense the questions because sometimes we get questions that are like a whole page long and it's difficult for us to condense it so that we can move through these questions quickly during First Fridays. Okay, so this is from a board. Our HOA in Northern Gila County has under 100 lots with wildfire risk. Our CCNRs require owners to maintain fire-safe conditions, including clearing vegetation within 30 feet of structures. Previously, board members inspected lots annually for compliance. Now we have a new owner with no trespassing signs and others with driveway gates. Can the HOA legally enter unfenced private lots for fire safety inspections, or do signs and gates affect this right? So if I were looking at this issue, I would look at what do your CCNR say? Does it give us a right of entry as a board to look at violations? If not, you may need to make an appointment with these owners to enter their property to make sure that they've complied with it. You may be able to do like an aerial view too. I don't know what the drone rules are in your association. I don't even know if you want to get into something like that, but that could potentially be another avenue. But the best thing would be if you're allowed access via your CCNR saying that you have a right of inspection as a board. Because they have gates and because they have signs, I probably would let them know you're coming so that there isn't an altercation. If you don't have that right, try to set it up with them. If they refuse to allow you to do that, which really honestly would be not very smart, maybe you can access this area that's adjacent to their home through one of the forested areas that's adjacent to it, that's open to the public. I don't know, maybe you have to think outside the box a little on this one to see if they have done what they need to do. Okay, another condensed version of a question from an owner. The HOA board commissioned an insurance matrix. Let's see. Okay, another insurance matrix. HOA board commissioned an insurance matrix detailing owner versus association responsibilities. And this is kind of a common thing, just so you know. A lot of associations, when they aren't sure, they don't think the owners know what they're responsible for or not responsible for, they create this matrix. And typically the association's attorney helps with it. Okay, so our board did this. A separate resolution requiring expensive plumbing changes was also created. Both documents claim prior approval by the board, but the matrix wasn't formally approved, and some board members were unaware of the resolution. Should the board have voted to approve the matrix at an HOA meeting, and does it belong in the HOA rule? So, I don't think they have to approve the matrix. I think that they can discuss the matrix after they get it back from whoever they commissioned it from, but I don't think a formal approval is needed for the matrix. But if they're changing plumbing requirements, I think that is something that should be voted on in an open board meeting. Okay, next question, number 20. And let's just give a little check here so I can see how many total questions we have. So we have 53. So we're at question number 20 right now. Okay, question 20 from a board member. A homeowner has expressed concern about a large HOA tree behind their home falling and damaging their property and the potential for injury. This homeowner is requesting the tree be removed at the HOA's cost. Large tree removal is costly, and a tree service company does not believe the tree is a high risk for falling. What is the HOA's liability for issues or damages caused by trees and tree leaves? You may want to have an arborist come out and look at the tree just to make sure get a second opinion from what your landscaper says. If there is no danger of the tree falling, I don't think that you're under any obligation as an association to remove the tree. If the tree would fall and you had knowledge that the tree was in danger, then there may be some liability for any damage that is caused by the tree falling. Maybe what the issue here is that the tree is dumping a lot of leaves into a pool, or they don't like the view blocking or something. Sometimes associations work this out by having the owner pay to have the tree removed. I don't know if the association doesn't want the tree removed for some reasons. I hate to see a good tree go to waste, obviously, and be removed. So just some different options that you have based upon that question. Okay, question 21. We're getting requests. This is from a board member. We're getting requests to enable homeowners to pay their dues via Zelle. Could you share your opinion on that, as well as any experiences you've had with the platform? Well, I haven't had any professional experiences with Zelle. This is the first time I've had a board ask this question to me. But I have had personal experiences with Zelle, and they've all been positive, meaning like paying vendors for my home, or, for lacrosse lessons for my daughter or whatever. And I haven't had any issues with it. I don't really like the fact that the Zelle platform, because I think for the purposes of running HOAs and condo payments for assessments, because, we typically have a platform for most associations to make their payments. And so it sounds to me like these people maybe are trying to go around that, and maybe Zelle doesn't have a fee or something. I don't know. I'd have to look at it a little more carefully, and I'd have to find out from the management company or the board, how would they keep track of these coming in via Zelle? And is it going to create more work? So at first glance, I'd say, I'm not really seeing this in our industry for payment of HOA and condo dues. It might be something that's a thing of the future. I don't know, but I like having a uniform payment method just because I think it keeps things a lot cleaner, and there's less chance of having a mistake or something not being credited that should be credited. Okay, next question is from a board. Because we are conducting our board member election electronically online using Vote HOA Now, And because we will have paper ballots available at the clubhouse front desk for members who want to use paper ballots and cast using the 2-envelope system in person at the clubhouse, must we also offer members the opportunity to vote and mail in ballots via the U.S. Postal Service. We will not mail ballots to our members. We do not allow emailed or fax ballots, and proxies are not allowed. Okay, so you're using an online election platform to conduct your annual meeting, which is great. A lot of associations are switching to that. There's new legislation that's proposed for this year that talks a lot about this. So this is obviously a timely issue, and associations are doing this. So the question is, so an owner can come and so we're doing the online election. So everybody's going to probably get like a notice of the meeting. They should get a notice of the meeting, and maybe they'll get a note card in the mail or a letter in the mail with their specific information for Vote HOA Now. And then you're going to have paper ballots available at the clubhouse front desk for members who want paper ballots. So you want to know, do we still have to mail ballots to the members? My short answer on this would be, I think I would have a letter in the notice that if somebody wants a paper ballot mailed to them, how they can do it. And if somebody wants to submit the ballot, I think I would give them multiple ways to do it if they want to do it by mail. So hopefully everybody will do by electronic. If they don't do it by electronic, then the second alternative will be they can go to the front desk at the clubhouse and get a ballot. You should have a sentence in your notice or in the information on HOA Vote Now that if you don't want to participate in HOA Vote Now, you can go to the clubhouse and get the ballot, or you can ask to have a ballot mailed to you, because a lot of people are out of state. So I think having that mailing option is necessary. And then give them a couple different ways to get the ballot back. If they're exercising the right to pick it up at the front desk, or if it's being mailed to them, I would accept it be mailed back by a date certain before the annual meeting. Also, don't forget, you have to allow people to vote in person at the annual meeting if they want to. So I would be sure to have ballots at the meeting and make sure that the notice indicates that as well. I know that's complicated, but that's just the way the law is right now, and you do have to follow the law on that. Okay, next question is from a board. It has been suggested that our board needs to have waivers for various activities to release us from liability for participation in these events. We encourage participation in owner-led water and chair aerobics, golf outings, attending live theater, various card and board games, coffees, lunches, dinners, sewing group, and pool tournaments in our clubhouse. What does Arizona HOA or condo law say about this issue? So it doesn't say anything. Like the Planned Communities Act and the Condominium Act doesn't say anything on this. Obviously, best practices would be to have a waiver for activities that may be inherently dangerous, or where there's issues that could come up where there could be an accident or something. Can an owner waive all their rights if the association is at fault on something? Like, I don't know what would be an example, but let's say that the association is hosting a dinner and everybody gets food poisoning. We probably can't waive our liability on that through a waiver. So is it a good idea? Yes, it's best practices. Try to get them for activities where there could be potential liability. Try to get the owners who are participating to sign them. There's nothing under Arizona law that requires it. And honestly, they can't really waive their rights if the association is at fault on something and then the owner gets damaged or injured, or the resident gets injured or damaged. Okay, next question, number 24. From a board member. Both our prior CC&Rs, the 2000 version, and our current CC&Rs, the 2020 version, include provisions regarding parking on streets within the community. However, the streets are maintained by Navajo County. Under ARS 33-1818, does our HOA have the authority to enforce these parking regulations? And if not, is the requirement to hold a membership vote by June 30th still relevant? So we have a great information that we're going to be sharing with you on Facebook Live and Zoom on this relatively new law in 33 Arizona Revised Statutes 33-1818. So here's the bottom line. Are you a planned community? I think you probably are, but double check. So you may want to reach out to our firm to help you double check on that. Secondly, I don't know if the streets are owned by the county. It sounds like they are if they're being maintained by them. I don't know. Looks like you're saying your CC&Rs, you have a 2000 version. And so basically a 2020 version as well. It sounds to me like you are going to have the requirement to hold that membership vote by June 30th, which is required by 33-18-18. If you want to continue regulating parking on the streets. And if you need help with this, reach out to our firm quickly, because we're telling a lot of our clients, like, hey, you need to be having your meeting to vote on keeping the regulation of your publicly owned streets. You need to be doing that like in April or May or early June at the absolute latest. And you got to like back it up and plan it out. So now is the time for your association to act, to get prepared on this. Okay, question number 25 from a board. The HOA CC&Rs were adopted 20 years ago. How often should the CC&Rs be reviewed and amended? And what are the steps that an HOA board should take to begin the review process of the document? So really good question on amending CC&Rs. We recommend that CC&Rs be amended about once every decade. We have a great cheat sheet on the process and how to amend your CC&Rs. It's called Amending Association Documents, a 5-step plan, which our office has sharing with you now on Zoom and Facebook Live. And you can also get a copy of it on our website at mulcahylawfirm.com. Also, our law firm does a free 15-minute review of for any association who's thinking about amending their CC&Rs. And so I encourage you to send us your CC&Rs. We'll do a free 15-minute review of what the process is to amend, what our suggestions are for your amendments, just very brief general suggestions, which would be a really good starting point for you to move forward on this project. But check out the cheat sheet to show what is the process step by step to amend your CC&Rs. Okay, question number 26 from an owner. Do violations of the governing documents have a statute of limitations in Arizona? Really good question. So generally speaking, yes. So it's a 6-year statute of limitations for a breach of contract. And the governing documents are a contract. If it's a negligence thing by the board, it's going to be a 2-year statute of limitations. So I hope that answers your question. Question 27 from a board. We also had to condense this question. 2 members of our HOA are engaged in a conflict. One member is urging the board to issue violation letters with fines for the other for harassing them, while simultaneously encouraging other residents on social media to complain about this person. The accused member reportedly drives around the neighborhood making faces at the complaint. The complaining member has sent the board information about HOA, HUD, and FHA regulations. Given this situation, what actions, if any, can or should the HOA board take to address this conflict between residents? Okay, we have a great article that we're sharing with you on neighbor-to-neighbor feuds and the association's involvement. I'd also suggest that you take a look at our federal laws cheat sheet, because we talk a little bit about when the association has to get involved in neighbor-to-neighbor conflicts. If there's any sort of like a protected class under the Fair Housing Act, we may have to get involved. I guess this is kind of a complicated question because I don't have all the facts, even though we condensed the question. And I don't know. I'd like to hear more about the alleged harassment and whether or not I need more facts to determine whether or not the board really has a responsibility to act. Most of the time, we tell the 2 owners, if you have a dispute, resolve it between yourselves and call the police or get injunctions prohibiting harassment against each other, and the board doesn't get involved. Other than maybe we might write a letter saying that we've received a complaint and we're making you aware of it regarding your behavior or whatever. But these are tricky. So reach out to our firm. We can help you navigate this situation. Okay, question number 28 from a board member. A while back, someone I know decided to show up and record their planned community HOA board meeting. The community has no formal recording policy in place. Once they saw the recording equipment, they quickly added an item to their agenda for that night and mentioned that homeowners who record meetings may not post them anywhere online, no matter what. Can they prohibit the person from posting the recording online? What about sharing the recording with another homeowner through email? Okay, so we have a whole cheat sheet that talks about Arizona open meeting law and rules for recording board meetings that I would encourage you to take a look at. So I guess the question is, could the board quickly add an item to their agenda talking about rules for recording meetings? So yes, under the statute, they are allowed to pass meeting rules regarding recording of meetings. So yes, they are allowed to do that. Can they pass a rule saying you can't record anything or post anything online that's been recorded at a board meeting, yes, they would have a right to do that. Is that going to be difficult to enforce? Yes, that's going to be very difficult to ensure that they're not doing that. If they didn't say you can't share the recording with another owner through email, I honestly don't think there's an issue with you doing that. I think you'd be fine doing that, although I wasn't at the meeting and I don't know specifically what their rules were. Okay, next question. Number 29 is from a resident in a planned community. There is construction of a home that not only blocks golf course view, but also appears to use setbacks or violate setbacks. Are setback building codes governed by the county or the HOA regulations? We are on Maricopa County Island and have heard that it was approved by the county. So really how setbacks typically work are that the county, city, municipality, they have a setback requirement typically that needs to be followed. The association can have a more strict setback if they so choose. But otherwise, the default would be to the city or county or municipality setback. So are they governed by county or HOA regulations? They're governed by both would be the answer. And the HOA's setback regulations can be more strict than the county's. Okay, question 30 from a board member regarding HOA board president's duties. Can that person make motions, second motions, and vote on motions as president? There's nothing stated in the bylaws on this. So my opinion on this is yes, the president can make motions, the president can second motions, and the president can vote on motions. I know that some associations don't operate that way, but I feel best practices is that the president should be allowed to do that unless it's prohibited in your association's documents. Okay, next question. Let's see, number 31 from an owner and a former board member. A fire in our association was officially attributed to a Kia fire by the fire marshal's report. However, the board falsely informed residents that the fire was caused by an owner's negligence, specifically storing lighter fluid on their patio. This misinformation appears to be an attempt to shift blame and potentially seek damages from the owner. Given that the board's statement contradicts the official fire marshal's report, can the association face legal liability for spreading false information about the fire's cause? I'm not sure I really even want to touch this one because the fire marshal's report typically is going to be kind of long on fires. I've read them before, and there can be multiple reasons why a fire is caused. It can be hoarding, it can be smoking, it can be a car fire, but it could be accelerated by storing gasoline in the garage or whatever the issue is. So I'm really going to kind of decline to interpret this too much. Maybe they had indicated in passing, I don't represent this association to the best of my knowledge. I have nothing to do with this situation, but maybe they're just reminding people not to have gasoline or whatever, or lighter fluid in their garages or on their patio because that could accelerate a fire if fire occurs. I don't really know the facts. So can the association face liability about spreading false information allegedly about the fire? Possibly. But I'd have to look at all the facts on this, and those cases are very hard to win. Basically, it's a defamation type thing. So I think that's pretty much all I want to say about that. Be careful. As boards, be careful what you put out there on different issues. Make sure that whatever you're saying is factual. And, as homeowners, be careful that you're not accusing the board of something that they may have just said in passing and you might be misinterpreting it. So I think that kind of cuts both ways. Okay, question number 32 from a board member. When must the board provide a resident the opportunity to submit a rebuttal or defense when they receive a violation letter or other charge, like for damaging HOA property? Is this stated in our documents or in the Condominium Act? So it depends. There is a couple ways to look at this. Every board should give a resident an opportunity to respond when there's a violation, right? And you're required, if there's a fine, a threat of a fine or a fine being levied, we are required to give them an opportunity to be heard. So when must they? So the answer on that would be the board must provide an opportunity to be heard if they send a violation letter and they're threatening fines or there's actual fines being imposed. And that opportunity to be heard can be, they can write back by email or US mail. They can come to a board meeting. It's really up to the board as to how they want to hear back from the owner. So This is stated in the Condominium Act under the fines statute. I mean, there might be something in your documents, but I don't have your documents, so I can't see that. But I mean, as best practices, boards should always be providing owners with an opportunity to be heard on issues. If we want to get them resolved, we want to listen, right? So there is also a statute that says that if after getting a violation letter, the owner writes back by certified mail asking for certain information regarding the violation, the association has to respond back within a certain period of time with that information if that information wasn't already included in the original violation letter. Okay, question 33 from a board. In Arizona, is an HOA considered to be a business? So short answer, yes. Almost 100% of associations in Arizona are considered a nonprofit corporation and are a business and should be operated and run like any business would be. Should the board have a fire inspection on the grounds and clubhouse by the fire department to ensure the association compliance with the City of Scottsdale Fire Code? I don't think it's required to have that. I mean, I check with the City of Scottsdale to see if they have any special requirements on that. It typically won't be. Maybe the take you're taking on this is if we're considered a business and all businesses have to have a fire inspection. Do we have to have a fire inspection? I think that's where you're going on this. I would check with the City of Scottsdale to see what their position is on this. It can't hurt. So I'm definitely not opposed to it. And we're seeing a lot of fire cases in the past 6 months. So it does happen. So it's always a good idea to have that checked. Okay, question number 34 from a board member. Understanding that you always recommend using a licensed contractor, we find ourselves in a difficult position with replacing a damaged countertop in our community restroom for a cost below the $1,000 threshold. The job is too small to get any bids. We do have a handyman with both liability and workman's comp who's willing to do the job, but several board members say we should not use them because they are unlicensed. Is it okay to use a handyman for this job? So I would say the majority of the board approves it. Yes, go ahead and do it. It's less than $1,000. It's not what I would call, there's a risk, right? If the contractor gets damaged or harmed in any way while they're installing this, there's a possibility we could get sued, and there's a possibility that we would have to pay out on this. I know that the handyman has liability insurance and workman's comp, so you should be okay with that. So in this circumstance, I would say it's kind of like changing the light bulb in a place at the association that's within reach and not dangerous. You may not have to hire a licensed handyman to do that. Obviously, best practices would be to always hire licensed and bonded contractors. But sometimes in situations like this, you can't find anyone to do it. So it's the only way to go. So I'm okay with it as long as the majority of the board is okay with that on this particular small job under the $1,000 threshold. Okay, question 35 from a board candidate and an owner. Great that you're listening in to get ready to be on the board. Our reserve study reports that we should have $500,000 plus in there, and we have less than $40,000 currently. What happens when an HOA is bankrupt? Okay, let's address two things. So number one, we have a great cheat sheet on reserves that I would recommend you take a look at. You can find that on our website at mulcahylawfirm.com. That just kind of talks about what a reserve study is, how reserves are used. It does appear that you are severely underfunded in your reserve. So you need to get some advice pronto on how you can start to fund that reserve monthly. The best place to look would be your reserve study. Hopefully it's been updated within the past 5 years so that we've got the current numbers, but your board needs to spend some time looking at that. Before you go too negative and say, we're going to have to file bankruptcy, I hope that's not the case. I think you really should spend your time on focusing on building the reserve. And if you get elected to the board, that should be something that should be one of your primary focuses for this year. Okay, what happens when an HOA files for bankruptcy? I've only seen it once in 28 years, one time, where an association was successful in filing bankruptcy. This is all public record, but this particular association had a very large judgment entered against them, and it was in northern Arizona, and it was basically a restructuring of the debt bankruptcy at Chapter 11, so they still had to pay everything. It wasn't like a discharge, just gave them time to restructure their debt. So it can be done. I've only seen it once, so it is kind of complicated. I do know the attorney that did it for the association. It was not something I was involved in on any level, but if your association's in that unfortunate situation, I do have a referral. Okay, question number 36 from another board candidate. Wow, different association. I'm loving that these people are listening to our classes today and running for the board and going into your time on the board potentially with, a lot of great education and knowledge. So good job. Okay, our board election is in February. If I become a director, what association information will I be privileged to review? You should be able to review everything unless there's like some lawsuit that was against you or something in the past, then you wouldn't be able to see that. But really, as a board member, you should be able to review everything for your association. Okay, next question, number 37 from a board member. Doing a quick check, looks like we have 54 questions. So we're on question number 37. An HOA general liability and property insurance policy contains a provision that says claims will be excluded from coverage if the HOA has failed to establish or maintain adequate reserves for the repair, replacement, improvement, or maintenance of any common area property. How would the adequacy of a reserve be authoritatively established? It seems particularly difficult question because Arizona does not license individuals performing reserve studies, and a majority of Phoenix HOAs are only 30 to 60% funded. Okay, I don't know where you're getting the facts about Arizona not licensing reserve studies and majorities are only X amount funded. Here's what I can tell you about reserves. Well, first of all, number one, I think it's really strange that your policy contains that provision. I haven't seen that before. It's possible that it's in the context of, hey, we don't cover maintenance claims. We only cover events, that would be like a broken pipe or something like that. But if there's like a leaky roof that the board's required to maintain, we're not going to cover that claim. I'd have to see the whole policy to see it in the context, but that would be my experience with a general liability and property insurance policy, and maintenance issues. So how is a reserve authoritatively established? You hire a licensed reserve company, and there are companies that are licensed through different national organizations, which would have a lot of experience in creating reserve accounts. I know that CAI, the Community Associations Institute, a national think tank for HOAs and condominiums, has a special license for reserve specialists. So if you hire somebody that has that special license, they would be qualified, in my opinion, to do a reserve study for your association. So how is it adequacy of a reserve going to be established? Well, you should have a reserve study done, and then you should look at what the reserve study says you should have in there in your reserve on that year, and then how much are you actually funded. Kind of a rule of thumb would be if you're funded 50 to 70%, you're probably okay. It would be much better to be 70 to 100% funded, but you're making an effort and you're not in a danger zone, so to speak. Okay, next question, number 38 from a board. Our CCNR state no RV parking on any street without prior written approval by the Architectural Committee. And per Senate Bill or per Arizona Revised Statutes 33-1818, we plan to retain that RV parking restrictions on our streets. Another CCNR limits street parking to 24 hours. Historically, the board allowed 48-hour parking for RV staging purposes with prior approval by the property manager. A member is ignoring the notification and time limit. These violations do not follow a consistent pattern and are often 4 or 5 days around the manager's set schedule. Homeowner filed a complaint. Can a board member or ARC member log each subsequent violation? The property manager says no, it has to be a written complaint each time unless the manager can log it personally. I disagree with the management company on this. I would say that if the board takes a picture of it and can document it, that you should be able to log each subsequent violation. Or a homeowner takes a picture and logs it. That information, as long as it can be proven with a photo or a video or something, the board member or a homeowner should be able to provide evidence of a violation. Okay, next question, number 39. We purchased a townhome in a planned community. After the closing, the HOA sent a violation notice saying the lack of a surround around the roof-mounted HVAC unit we missed during the pre-sale inspection. However, it is still required to be put up. The HVAC unit was installed at least 5 years ago and a surround was never put in. The next door neighbor is on the board and I can see the unit and he can see it from his upstairs. It is not visible for any other part of the community. I don't know why they didn't require the prior owner to put it in. Are we required to add it since it obviously was never there before and it was missed in the pre-sale inspection? Short answer on this would be, I think since it's been there for so long, they can't require you to do that. So anything over 3 years on something like this, they can't require you to do that. If you want to do it to be a good neighbor, you certainly have the right to do that, but they can't force you to do it, in my opinion. Okay, question 40. If not part of the original signed management agreement, can the management company insist on a community using a preferred vendor program? Sometimes there are not enough preferred vendors to provide multiple estimates, leaving the community at a disadvantage. This does kind of rub me the wrong way, honestly. I'm going to just be honest with you on this. So some management companies are creating these preferred vendor programs, and I think the intent of it is good, in that the intent of it is that they want to make sure that licensed, bonded, and insured vendors are doing work at your association. But sometimes they only put the vendors that are like the companies that are part of their management company, another arm of their management company, or maybe they will only do certain landscape companies and they refuse to allow an association to hire a landscaper that is licensed and bonded because they're not in their preferred list or whatever. So it's complicated, but if it's not part of the original signed management agreement, I don't think that they can force you to use the preferred vendor program. But I think you should take a strong look at, hey, maybe they're trying to save you from making a bad choice. So is there a reason why they don't want you to use this vendor? Have that dialogue with them. And maybe it's because they're not licensed or bonded. If it's just because they don't like the vendor, or they're not their preferred attorney, or they're not their preferred pool company, that may not be enough to make you're in charge. You're the boss. There's nothing in the contract that says you have to use their preferred vendor program. So ultimately, you make the decisions. Okay, question number 41 from an owner. Our board of directors recently changed a bylaw so that 2 board members that were appointed did not have to be elected at our annual meeting. As our bylaws state, the board did not follow the steps outlined in our bylaws for changing the bylaw and did not even tell us what that change was at our meeting. They had the property management company send a letter the next day explaining the change. Our community is angry. Do we have any recourse as homeowners? Thank you. Okay, so it sounds like the board changed a bylaw. That needed to be done in an open board meeting, and the agenda should have indicated that there was going to be a bylaw change so that members who are interested should be allowed to attend. Don't know, it sounds like your board didn't follow that procedure. So I would just express your concerns in writing to the board. Ask for the minutes where the bylaws, ask for the notice of the meeting or the agenda for the meeting that was, showed that this was going to be discussed. Ask to see the minutes where the board allegedly made this decision. Ask the board to revisit the decision if you're not in favor of it. I mean, obviously you have rights. You could go to the Arizona Department of Real Estate, file a complaint. You can do a removal petition of your board. You can run for the board yourself the next time there's an election. Lots of different remedies for you to deal with this situation with your board. Okay, next question is from one of my favorite clients. Good to see you here today, the board. Some of our residents are concerned about possible power outages during the sweltering days of summer. They've asked us to look into purchasing a backup generator for a common area, such as a clubhouse or studio, so they have a cooling station. Are there liabilities issues we should be aware of if we were to install a backup generator? I don't see any liability issues. I do know that they're very loud and you have to test them once or twice a month to make sure that they're working. So, that could potentially be a nuisance issue, but I kind of feel like you weigh that. The generator is going to help you out in the bind if there is anything that really serious happens. So I don't see any liability on it. I don't know how much it's going to cost, if it's cost prohibitive or not, but it seems to me like that would be something your board would be okay with looking into and purchasing, as long as you understand, how much it's going to cost and there are maintenance issues with it. I mean, I guess, are you worried that it's not going to work in the event of a power outage? That's always a risk, but if you're doing those inspections once or twice a month, it should be working. Okay, question 43. Our community had its annual meeting last Sunday. I turned my vote in on Thursday. They had 3 openings and 5 were on the ballot. On Saturday night, 1 member dropped out, and that does happen. I received notice on Sunday at the time of the meeting that another member volunteered, and would we call and inform the board that we would vote for him? Okay, that should not have happened. Just the phone call and somebody being added, none of that doesn't sound right. He lived on the property for 2 weeks. He was not on the ballot, and I have never seen this done. I was on the board for 12 years. Today, plants were all removed in our community. I believe there was rigging. Was this a legal action? So I don't know about all the other ballots, but I can tell you that your ballot was voted on Thursday. There's nothing you can do to change that ballot. There's nothing that could be done to change any of the ballots that were submitted prior to Saturday night when the one member dropped out. So if they were trying to call people to change their vote afterwards or to add somebody to the ballot, that was improper in my opinion. Okay, question number 44 from a board member. This is a condensed version as well of the question. Can we file a complaint with the Arizona Corporation Commission against a statutory agent who has not responded to our inquiries about a property owned by an LLC? We've attempted to contact the agent, the owner of the empty lot, by email and phone regarding HOA dues and plans for the property, but have received no response. I mean, I don't think the Corporation Commission is going to care. I hate to say it that way, but we have this situation from time to time where maybe they want to be served with the paperwork. I think, as it sounds like, the actual owner of the LLC to help you write a violation letter and to track down the owner to get them to comply. I don't think the Corporation Commission is going to help you on this one. Okay, question 45 from a board member. What is the update on the BOI through the Corporate Transparency Act? Do you have to sign up for this? Would your HOA be fined, or is this still on hold? Which looks like it is from your last email we received. Okay, so we talked about this just briefly at the beginning of the class today. So short answer would be right now there's a stay, meaning you don't have to file the BOI. But I think that's going to change in the very near future, probably in February or March, because the United States Supreme Court ruled that associations and other businesses have to comply with this in January. And then there was another court case that they haven't heard yet that said that they don't have to. So the stay is still in place. So bottom line here is, I think the writing's on the wall that you're going to have to do this unless there's some sort of U.S. Congress law that's passed to change the requirements so HOAs and condos don't have to do it. I don't think that's going to happen fast because there's a lot of other things going on right now in our government with the new administration and the transitions that are occurring. So my feeling is, if I were advising a board, I would say either be ready to file it. So as soon as the other Texas case goes up to the Supreme Court, or as soon as the appeal of the other case is heard by the Fifth Circuit, you can file it right away. So be ready to do it, have everything done and be ready to file it, or actually just go ahead and file it. That's the best advice I would give you. Of course, since the stay is still in place, you can just say, I'm not doing anything on it, but recognize that once the Fifth Circuit hears the appeal on this, it's going to be a 50-yard dash to get this filed, and everybody's going to be trying to do it. So it could be complicated and stressful to get it filed, especially because our experience with the website on FinCEN that's accepting the BOIs is it had difficulty at different times when there was a large number of BOIs being processed and filed at the same time. And the system was freezing and it was making it much longer to file them. That's just the skinny on it. Keep following our website, come to our classes, subscribe to our Mulcahy memos by contacting us by info@mulcahylawfirm.com to make sure you get the most updated information so you're always on top of what's going on with that. Okay, question number 46. My HOA is planning an annual meeting. The election of homeowners to the board of directors will be done by paper ballot. We are requesting our homeowners to also vote on an additional issue. Can more than one issue be placed on the paper ballot, or do we need each item on its own ballot? So they all can be placed on the same ballot, no problem. If there's just one thing I'd say is, like, if there's a different requirement for the second issue, make sure you say what the requirement is. So like the second issue is a special assessment that may require 67% of those attending the meeting to approve it. Put on the ballot what the special requirement is for each item they're voting on, if there is one. Okay, question number 47. Looks like we're at 56 questions, so we're getting close to the end. This is also a condensed version of the question. I'm going to ask again, please, when you're submitting questions, please keep them short because it does take a lot of time to condense these questions when they're submitted and they're really long. Okay, condensed question from the board. The board has approved a reserve study update from the previous company in an open meeting. However, the president later refused to sign the invoice, requesting additional bids. Despite being informed that an update was more cost-effective than switching companies, the president insisted on documentation showing the lowest bid was chosen. Management proceeded to order and pay for the study without informing the president, who expected a revote by the next year's board. It appears management split the invoice in two payments to bypass the approval limit, requesting a signature. What's this action by management, legal and professional? Okay, I'm seeing bad behavior on both sides of this. So, okay, if the board approves a reserve study update, the board approved it. So you move forward with that unless the board unapproves it. Okay, so the president refusing to sign the invoice, that's bad behavior. That's not consistent with their fiduciary responsibilities to the corporation. If the president didn't want to sign it, he should have said, hey, board, can we notice a meeting 48 hours from now and talk about this? I'm concerned about it. Can we revisit this? Doesn't sound like that happened. So it's fine that the president was expressed concern. I mean, sometimes you do have voting remorse, but you should take action to talk about it with the board. You can't just hold the board hostage by not signing it. Then we've got the management company on this who decided they didn't know what to do. They wanted to get around the invoice approval limit requirement. So they split it into two invoices just to get it done. I mean, honestly, the management should have done the same thing. They should have said, hey, we're having an issue here. The board gave us direction to do this. The president's giving us direction to do this. We need to talk about this at a meeting to give us clear direction on how you want us to handle it. So was the action by management legal? Well, yeah, because the board approved the reserve study update. So, I mean, technically they had the right to move forward on this. Was it professional? I think I probably would word it in like, hey, I think a better way to handle it would have been to get the whole board back together to talk about this issue. Okay, question number 48. Our new board of 18 days are rapidly making major changes without discussion of stakeholders and not in compliance with our bylaws and the proprietary lease. What can we shareholders do to stop them? Okay, so I don't know what it looks like you're a cooperative, which is a little bit different than a condominium or a planned community. So I want to mention that. You're typically not subject to the Condominium Act or the Planned Communities Act. So you just have to abide by your association's bylaws. You know, what can we do as shareholders in a cooperative? I would just express your concerns, write to them, ask for a meeting, look at your documents to see what sort of rights you have to remove them, get an attorney. These are all different things that you can do. Okay, question number 49 from a board. A homeowner has requested that the association pay for new fencing around a common area that is adjacent to a busy street. The homeowner has indicated that vagrants sometimes stay in the park. This is not something that is in our reserve study, so no money has been set aside for this type of expenditure. What is the best course of action to ensure that the board is doing its due diligence? Well, I think I would talk about it with the homeowners that are adjacent to this common area and say, hey, is this a concern? And have there been any incidents with the homeless people? And weigh the potential danger to the community will the fence be something that could help us with this? Or other people complaining about it other than this owner? Is there adequate lighting there that could be done that might help us, in the same manner and be less expensive? I would talk about this at a board meeting. I'd invite the neighbors that are in this area to come and talk about it. I'd get a bid for the fence, what you're dealing with in terms of the cost. I don't think you're necessarily required to do it, but I think you do need to do your due diligence and look into the problem, look into the cost of the fence, look into what other things might be used to mitigate this issue. Talk to the other neighbors who surround this area, see if they think this is a problem too. Okay, next question, number 50 from an owner. Our HOA is in the third year of developer control. The developer's budget is set according to 100% of the lots paying, but many of the lots are unsold and therefore income is well short of the budget. It appears that the developer is underspending to match income from owners so they do not have to cover any shortfall. Is this a legal issue or just an ethics issue? Any suggestions? Well, I'd have to look at your CC&Rs to see what specifically the developer's responsibilities are in terms of paying for shortfalls, et cetera. And obviously the developer would have to maintain the association at a level so that it's being properly maintained. It does seem like an issue that if you, as a homeowner, I would recommend that you write a letter expressing your concerns. You may even want to get an attorney. You may even want to get a group of like-minded homeowners together to show power in numbers to the developer that you're not happy about how things are going and the properties, you're not spending enough to maintain the property, et cetera. And if the developer doesn't respond, then you may need to go the legal route and have an attorney help you with this situation. Question 51 from a Secretary Treasurer. What federal or state law, privacy law, can we refer to when requesting that homeowners stop sending mass emails to other homeowners that contain the personal name and email addresses of other homeowners? A recalled president took the association mailing list and personally emailed a mass email that visibly contained 156 homeowner names and emails. We understand that recalled president's action violated his fiduciary responsibility, but how do we best ask homeowners on that original email string to stop perpetrating this behavior by using that original email years later? Well, the emails are out there to everybody in your community, and so there's probably really not much you can do. I guess the best thing that I've seen this problem before, by the way, is if the owners are upset about it, they need to write a letter to whoever's emailing them, email them and say, stop emailing me. Us telling the former board member that was removed, stop emailing the community. The emails are out there. And I don't think that's probably the way I would approach it, because they're not going to. And they're going to say they got them from some other source. They're not going to say that they took them from their time as president. I mean, I've been through this dog and pony show before. So I think maybe sending a letter to the entire community saying, hey, we understand that a former board member, or maybe you don't even go there because you don't want to get involved in, like a legal issue with this former board member. Maybe what you just say is, it's our understanding that an owner has obtained individual emails of all owners and is emailing everybody regarding whatever. If you don't want to be emailed by this person, respond back to that person and tell them to stop emailing you, and then just leave it at that. I mean, you could do that, or you could just ignore it too. One thing, if you have somebody out there who's kind of like a gadfly that's doing stuff like this, I really recommend that you pump up your communication to the owners on what's going on at the association, because this former board member is probably pumping misinformation, making the board look bad, saying you're not doing your job, whatever. And I've been seeing this before. So you have to have good communication so that this owner doesn't get a following, and so that this owner doesn't start spreading so much misinformation that people start believing it. So have a town hall meeting to discuss issues. Send out frequent emails or newsletters regarding positive things that you're doing, challenges that you're facing. Invite people to come to your board meetings. Encourage people to come to your board meetings. Be sure you're posting your notices for your board meetings and your agenda 48 hours in advance. Okay, next question, number 52. From a board, if our board, 5 directors, meets for board training, is that required to be open to all homeowners? For example, a Mulcahy Law Firm boot camp. So great question. So if it's a boot camp by our firm, it would be considered an executive session because you'd be getting advice from your attorney. So that would not need to be open. So if the board training is conducted by an attorney, then it wouldn't need to be open to all members, but you would still have to notice it and provide an agenda stating, it's an executive session and that which section under the statute it falls under, which would be advice from your legal counsel. Okay, question 53. Before a new board election, what date all dues must be paid by a candidate who is late on HOA dues? Is it a date when voting ballots are sent, or is it okay if they pay them just before the ballots are read? Check your documents, because sometimes your documents have what they call a recording date, which means like the date before the annual meeting or before the meeting that you have to be current. Most don't, but sometimes they do. So I'm mentioning that. I would just put a notice on the ballot when you send it out as to what the policy of the board is going to be and vote on it at a board meeting. I think as long as they pay it in advance and make sure the check's cleared and everything. So I would say like maybe 10 days before the meeting or a week before the meeting, that should be fine. Just put that on the notice or on the ballot so that people are aware. If you're not current, you won't be, allowed to participate in the election, assuming that your documents allow you to withhold owners from voting if they have a balance due to the association. Okay, next question. Let's see, number 54. My management company representative on site gave us permission to host an event in our community center with no mention of a fee. At the event, the board president walked in and said we had to pay $250 and put $250 on my account. I'm appealing to the board, but I don't think they will budge. Is this proper? I mean, I don't know what kind of an event it was. The whole situation seems odd, frankly. If you were having a community meeting, you should be allowed to use that room, in my opinion, for free. I don't know what the event was. I don't know what the discussion was with the management company representative. Was there some sort of an agreement written, or was there an email? Or did the management company reps mention that there was a cost? I don't know all the facts on this. Is there like a cost schedule for your association to use those facilities? If so, then you may be responsible to pay for it. So a lot of unknowns here, but I'll be interested to hear what happens when you appeal to the board. Okay, question number 55 from a board member. As a new board member to a board that's not really transparent, when I ask questions, I'm automatically sent to the attorney and told I'll be charged as a board member. I receive no answers from office director, and it's a very hostile situation. How do I get answers without getting attacked by other old members or getting sent to the attorney? I'm not asking anything out of the ordinary, and as a board member, why can't I ask questions? They won't answer me. I'm worried they're hiding things. Okay, so I'm concerned too. I mean, it's odd. The situation is odd based on the facts that you're telling me. So I think boards should strive to be transparent to all owners. If you're a director of the association, a board member, they have to be open with you about everything. And you should be having a fruitful dialogue on issues pertaining to the association. And it's okay for you to ask questions. Now, there's a difference between asking reasonable questions and just being annoying. Sorry to say it that way, but I serve on 2 boards. I know what it's like. On one of the boards that I'm serving on right now, we have a board member who is very difficult to the point that our manager is threatening to quit. And, I hope you're not that person. I hope that you're the person that's just asking questions in a reasonable manner and not sending 500 emails in a 2-month period or anything like that. So I have to hear both sides of the story from this, from the board and from you. And really what you guys need to do is have a boot camp, because there's some dysfunction here. And maybe our firm can come in and help you resolve the dysfunction. Now, just so you know, as an attorney that practices in this area, I would never individually charge a board member the way that this is going down at your association, or they're telling you it's happening. That is totally improper. The attorney cannot individually represent you. And if they're charging you to answer questions, they're individually representing you. So that's an issue in my opinion. Okay, question number 56, our last question for today. We are 38 individual homes with no common property. Our only expenses are corporation filing fee annually of $10. Insurance to cover the board, which is less than $600 annually. Do we even need a reserve study? So I would say, no, you don't, because you don't have any common areas. Okay, so we got through a lot of questions today, 1 hour and 37 minutes, record time for 56 questions. So thanks for all the great questions today. Appreciate you being here to want to improve your associations, whether you're a homeowner, a board member, or a manager. Just a few concluding remarks for today. We have 2 more learning opportunities this month that we want to make you aware of. So on Saturday, February 15th, we are going to be teaching a live class at the Scottsdale HOA and Condominium Symposium. We are one of the speakers for that day, and we're going to be joining attorneys from across the valley to present at the Scottsdale Spring HOA Condo Symposium. Our firm is going to be leading a session on board member roles and responsibilities, while other attorneys in attendance are going to address various important topics for HOA and condo board members. I believe it's a multi-hour event. I think I'm speaking in the afternoon, but I think it starts mid-morning and it goes into the afternoon. If you're interested in hearing more about this class, go to our website at mulcahy.com and click on upcoming classes or seminars, and the link will be there. I would encourage you, if you're interested in attending, sign up fast, because I hear it's selling out. So Saturday, February 15th, in-person class. I don't know if there's a charge, but it will be listed on our website if there is. The second opportunity for learning is February 18th, which is a Tuesday. This is our second class of the virtual HOA Condominium Academy that we teach in conjunction with all the neighborhood services departments in the Valley. We do this class every month on the third Tuesday of every month. And this particular class is going to be a virtual class on Zoom or Facebook Live. And you can join us for an in-depth overview of HOA and condo board meetings. We're going to give you tips on how to have a 1-hour board meeting. We're going to talk about recording meetings, like we talked about a little bit in this First Fridays today, how to handle problems that come up with board meetings, whether it's board members fighting or it's difficult owners. We're going to talk about the pros and cons of in-person versus virtual meetings and how to best run both of them. And we're also going to talk about annual meetings. Because we know that this is kind of what we call annual meeting row right now. Between February, March, April, and May, a lot of associations are having annual meetings. So we're going to give you some tips on how to have a successful annual meeting. So thanks everybody for being here today. Happy Valentine's Day, a little bit early to all of you. Hope you have a wonderful month, and I hope to see you at one of our other 2 learning activities this month. On February 15th or February 18th. And don't forget, we're going to be having our March First Fridays on the first Friday of March in 2025. So don't forget to join us again then. Take care, everybody. Have a great month. Hope to see you soon. Bye.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.